Before we begin, a quick and important disclaimer. This video is intended strictly for educational and entertainment purposes. The historical trends, case studies, and legal evolutions discussed do not constitute legal, financial, or professional advice. The American legal system is incredibly complex and varies significantly by jurisdiction. Laws regarding domestic relations, asset division, and parental rights are subject to change and interpretation by individual courts. This content does not create an attorney-client relationship. If you are facing a legal matter, you must conduct your own due diligence and consult with a licensed professional in your specific state to address your unique circumstances. We are reviewing a century of history to understand a system, not to provide a roadmap for individual litigation. Imagine it is the year 1926 in New York City. You are trapped in a marriage that has become a psychological or physical prison. There is no such thing as irreconcilable differences. There is no simple filing for a no-fault dissolution. In the eyes of the law, marriage is a permanent, sacred contract that the state has a vested interest in maintaining. To break it, you don't just need a lawyer. You need a strategist, a storyteller, and often, a participant in a grand legal theater. At this time, the only way to secure a divorce in many states is to prove a statutory fault, most commonly adultery. This led to the rise of what historians call the era of the manufactured raid. An attorney would hire a private investigator, who would hire a professional witness, who would then be found in a staged scene in a hotel room with the husband. The attorney would then present this fabricated evidence to a judge who likely knew the scene was staged, but followed the script because the law demanded a villain and a victim. This was the birth of the modern American divorce attorney, a professional force to operate within a system that demanded conflict, even when none existed, just to provide the relief of a fresh start. Today, the American divorce industry is a multi-billion-dollar sector, but its roots are buried in these high-stakes, often clandestine maneuvers of the early 20th century. We are currently looking at a century-long evolution where the role of the lawyer has shifted from a moral gatekeeper and a fixer of manufactured evidence to a sophisticated architect of financial equity and a navigator of complex psychological landscapes. If you look at the statistics, roughly 35 to 50% of first marriages in the United States end in dissolution, and that number often climbs for subsequent marriages. This means that at some point, a significant portion of the American population will find themselves sitting across a mahogany desk from a specialist whose entire career is dedicated to the deconstruction of a domestic life. The reason we are conducting this deep dive masterclass today is because the system you see in 2026 is a direct byproduct of 100 years of social friction, legislative overhauls, and landmark court battles. Many people entering the legal system today feel blindsided by the costs, the duration, and the adversarial nature of the process. They wonder why it feels like a battle even when both parties want to move on. The answer lies in the DNA of the American legal framework. By understanding the historical trends from the 1920s to the present, you will gain a perspective that moves beyond the emotional turmoil and into the realm of strategic understanding. This video solves the problem of the opaque legal machine. We are going to strip away the mystery of why the system functions the way it does, how the attorney's role has transformed from a scriptwriter of perjury to a high-stakes negotiator of digital assets and retirement accounts, and what that means for the potential outcomes of cases in the modern era. Consider the 1930s and 1940s, where the concept of the divorce mill began to take shape. Places like Reno, Nevada, became the epicenter of a legal industry because they offered shorter residency requirements and more lenient grounds for filing. This created a socioeconomic divide. If you had the financial means, your attorney would book you a ticket to a Reno ranch where you would wait out your 6 weeks of residency to obtain a decree that was impossible to get in your home state of South Carolina or New York. This historical trend highlights a fundamental truth about the American divorce attorney. They have always been the bridge between restrictive state morality and the individual's desire for autonomy. This period saw the rise of the celebrity divorce lawyer, the one who could navigate the interstate jurisdictional nightmares that arose when one state refused to recognize a decree from another. As we move through this review, we will examine the seismic shift of the 1970s, specifically 1969 when California Governor Ronald Reagan signed the first no-fault divorce law. This single piece of legislation fundamentally altered the career path of every domestic relations attorney in the country. It moved the focus from proving who was the bad actor to a cold, calculated division of assets and responsibilities. However, as we will see in the coming sections, taking the fault out of the legal filing didn't necessarily take the conflict out of the courtroom. It simply moved the battlefield. Instead of arguing about who was seen at a hotel, attorneys began arguing about the valuation of a closely held business, the future potential of a professional degree, and the intricate nuances of primary residential responsibility for children. This masterclass is designed to provide you with a comprehensive educational framework. We are going to look at the data surrounding the rise of the equitable distribution model versus the community property model. We will analyze case studies from the mid-century that defined how alimony, now often called spousal support, evolved from a lifelong pension for a wronged wife into a rehabilitative tool designed to bridge the gap toward self-sufficiency. We will also explore the massive technological shifts that have occurred leading up to 2026. In the early 1900s, an attorney's evidence was physical: letters, photographs, and eyewitness testimony. Today, a divorce attorney is often a digital forensic analyst, scouring cloud storage, cryptocurrency ledgers, and social media footprints to build a case for the division of a modern estate. The problem for most Americans today is that they approach the legal system with the 1950s mindset of win or lose, while the system itself has evolved into a complex administrative and financial audit. By the end of this 10-part series, you will understand the mechanics of the billable hour, the psychology of the courtroom, and the legislative history that dictates how your home, your savings, and your time with your children are partitioned. We are going to look at how the attorney's fees themselves became a point of litigation, and how the rise of mediation and collaborative law is the latest chapter in this 100-year saga. This isn't just about history. It's about the current reality of the American family. We are living in an era where the silver divorce among those over age 50, is at an all-time high, presenting new challenges for attorneys regarding Social Security benefits and long-term care insurance. We are seeing the emergence of pet custody battles and the valuation of personal brands and influencer income. The American divorce attorney has had to become a polymath, blending the skills of a therapist, a tax accountant, a private investigator, and a constitutional scholar. We are going to break down every one of these roles, providing you with the depth and detail required to see the system for what it truly is: a mirror of American society's changing values over the last century. Prepare for a deep dive into the evolution of the law, the people who practice it, and the lives that are reshaped by it. To understand the American divorce attorney of 2026, we must first descend into the legal trenches of the 1920s and 30s, an era defined by a concept known as the tripartite marriage. In this period, marriage was not simply a contract between two individuals. It was a three-way agreement where the state held the most powerful vote. The state had a vested interest in the stability of the nuclear family to ensure economic order and moral conformity. Consequently, the legal threshold for dissolving a marriage was intentionally set at an astronomical height. If you were an attorney in 1926, your job was not to negotiate a fair settlement. Your job was to prove a crime. Historical trends of this era show that the vast majority of states required a specific statutory fault to grant a decree. The most common were adultery, extreme cruelty, or desertion. If both parties wanted the divorce, the law viewed this as collusion, which was actually a grounds for the judge to dismiss the case entirely. Imagine if today, in 2026, two people walked into a courtroom and said they both wanted to move on, and the judge responded by forcing them to stay married because they agreed too much. That was the reality. This created a paradoxical environment where attorneys had to become masters of a very specific kind of theater. In New York, for instance, adultery was the only ground for decades. This led to the emergence of the professional correspondent. An attorney would coordinate with a private investigator to hire a woman who would be photographed in a hotel room with the husband. Both would be fully clothed, often sitting on the edge of the bed reading a newspaper. But the mere presence of a woman who was not his wife in a bedroom was sufficient for the court to grant the decree. This staged performance was a calculated risk. If a judge suspected the evidence was manufactured, the attorney faced the potential outcome of disbarment. Yet, the social demand for marital exit was so high that a shadow industry formed. We see case studies from this era where elite law firms had specific investigators on retainer whose entire job was to manage these raids. The step-by-step process was chillingly methodical. The PI would track the husband to a prearranged location, the attorney would ensure the paperwork was ready, and the witness would testify with practiced rehearsed lines about what they saw through a keyhole. This was the first iteration of the divorce attorney as a strategist of optics rather than a practitioner of family law. However, not everyone could afford a staged raid or the social stigma of being labeled an adulterer in a public record. This led to the second major historical trend: the migratory divorce. In 1926, if you were a person of means, let's call her Evelyn, a socialite from a restrictive state like South Carolina, your attorney wouldn't file in your home county. They would put you on a train to Reno, Nevada. Nevada had discovered a lucrative economic model by lowering residency requirements to just 6 weeks and offering wide-ranging grounds for divorce, including the vaguely defined extreme mental cruelty. This created the Reno divorce ranch industry. Attorneys in Reno became the first high-volume specialists, handling thousands of cases for out-of-state residents. This created a massive legal conflict regarding the full faith and credit clause of the U.S. Constitution. Imagine the chaos if a Nevada court said you were single, but your home state of North Carolina said you were still married and threatened to prosecute you for bigamy if you remarried. This isn't a hypothetical. It was the core of the landmark case Williams versus North Carolina. In 1942 and again in 1945, the Supreme Court had to grapple with whether one state was required to recognize a divorce granted by another, when the residency was clearly a legal fiction created just to bypass local laws. The potential outcomes of these rulings fundamentally shaped how attorneys today handle interstate jurisdictional disputes. The court eventually ruled that while states must generally respect the decrees of others, they could inquire into whether the person was truly a bona fide resident. This forced attorneys to become even more detailed in their documentation, advising clients to open bank accounts, join local churches, and get Nevada driver's licenses to prove they weren't just tourists. As we moved into the 1950s, the attorney's role shifted again. The post-war era brought an obsession with the domestic ideal, yet the underlying reality was a surging divorce rate as returning veterans and women who had entered the workforce found their pre-war lives no longer fit. The legal system, however, remained rigid. This was the era of the Bill of Particulars. If you were accusing a spouse of cruelty, your attorney had to draft a document listing every single slight, every argument, and every instance of supposed misconduct in excruciating detail. This wasn't about a global view of the marriage, it was a weaponization of memory. For example, an attorney might spend 10 pages arguing that a husband's refusal to allow his wife to drive the family car constituted a form of mental torture sufficient to break the legal bond. During this period, the financial role of the attorney was also nascent. There was no equitable distribution in many states. Instead, the law followed title. If the house was in the husband's name, it stayed with the husband. Alimony was the only mechanism to prevent a divorced woman from falling into immediate poverty, but it was almost always tied to fault. If a wife was found to be at fault for the breakdown of the marriage, even if she had been a homemaker for 30 years, she could be left with nothing. This made the divorce attorney a high-stakes negotiator of survival. They had to balance the moral posturing of the courtroom with the cold reality of their client's bank account. By the early 1960s, the tension between the law and social reality reached a breaking point. Attorneys were tired of the perjury. Judges were tired of the staged raids. The public was tired of the hypocrisy. The system was essentially a pressure cooker. We began to see the rise of the organized family law bar. Groups of attorneys pushing for legislative reform to bring the law in line with how people were actually living. They argued that the adversarial nature of the fault system was destroying families and poisoning the lives of children involved. They started to advocate for a radical idea, that a marriage could end simply because it had broken down, without a villain and without a victim. Imagine the professional fear for these attorneys. They were advocating for a system that would effectively eliminate the need for the high-drama investigations and complex fault-finding that had been their bread and butter for half a century. They were moving toward a future where the attorney would have to be less like a prosecutor and more like an accountant. This transition was not immediate, and it faced massive resistance from religious groups and conservative legislators who feared that making divorce easier would lead to the total collapse of American society. Yet, the momentum was unstoppable. In the next part of this masterclass, we will look at the exact moment the dam broke. We will analyze the 1969 California legislation that changed everything and explore how the role of the attorney shifted overnight from a moral detective to a financial engineer. We will see how this shift created a new kind of war, one fought not over hotel room photos, but over pension funds, stock options, and the very definition of what constitutes marital property. If the first 50 years were about proving who was wrong, the next 50 would be about calculating who gets what. But as we move into that era, a new question emerges. When you take away the need to prove a crime, does the divorce process actually become faster? Or does it just become more expensive in a different way? The answer lies in the rise of the modern billable hour and the birth of the complex discovery process, which we will break down step by step in our next section. The year was 1969, and the setting was the office of California Governor Ronald Reagan. When he signed the Family Law Act into law, he effectively dismantled the legal framework that had governed American domestic relations for over a century. This was the birth of no-fault divorce, a legislative earthquake that transformed the American divorce attorney from a moral detective into a financial engineer. Before this moment, an attorney had to build a narrative of blame. After this moment, the narrative became one of arithmetic. To understand the attorney of 2026, you must understand this pivot point because it created the modern complex discovery process that dictates the cost and duration of legal proceedings today. Imagine a character named Michael, a practicing family law attorney in 1972. Under the new no-fault statutes, Michael no longer spends his nights coordinating with private investigators to catch a spouse in an act of infidelity. Instead, he spends his days in the basement of a courthouse or in a room full of bankers' boxes, perfecting the art of discovery. In a fault-based system, the leverage was the shame of the public record. In a no-fault system, the leverage is the transparency of the balance sheet. This shift gave rise to the four-step discovery process that remains the backbone of family law. First, there are the mandatory disclosures. In current 2026 practice, this has evolved into a high-tech digital audit, but in the 1970s and 80s, it began as a requirement for both parties to lay their cards on the table. This includes every tax return, bank statement, and deed of trust. Step 2 involves interrogatories. These are written questions that the opposing party must answer under penalty of perjury. Michael would use these to hunt for hidden assets, asking about offshore accounts, safe deposit boxes, or cash kept under a mattress. Step 3 is the request for production of documents. This is where the attorney demands physical or digital proof of every claim made in the interrogatories. If a spouse claims they have no savings, the attorney demands 3 years of canceled checks to see where the money went. Step 4 is the deposition. This is oral testimony taken outside of court but under oath. It is a psychological and factual interrogation, where the attorney tests the consistency of the witness. As the requirement to prove fault vanished, the battlefield shifted to the definition of marital property. This created a historical trend toward what we call the equitable distribution model and the community property model. In community property states like California or Texas, the law generally views everything acquired during the marriage as owned 50-50. In equitable distribution states like New York or Florida, the court looks for a fair division which might not be an equal one. This distinction created a massive new niche for attorneys: the valuation of the intangible. Consider the landmark case study of O'Brien v. O'Brien in 1985. In this New York case, the court had to decide if a medical license acquired during the marriage was a marital asset. The husband had become a doctor while the wife worked to support him. When they divorced, she had no degree, but he had a massive future earning potential built on the back of her labor. Her attorney argued that the license itself was property. The court agreed, ruling that the enhanced earning capacity was an asset subject to distribution. This changed the game. Suddenly, a divorce attorney had to be a vocational expert and a math wizard, calculating the present value of 30 years of future surgeon salaries. This era also saw the rise of the forensic accountant as a mandatory partner for any high-stakes divorce attorney. Imagine if you are a business owner in 1988. Your spouse's attorney isn't just looking at your bank account. They are hiring an expert to perform a lifestyle analysis. If your tax returns show you earn $50,000 a year, but you drive a luxury car and vacation in Aspen, the attorney uses forensic accounting to argue that you have unreported income or that you are using your business as a personal piggy bank. They look for personal expenses disguised as business deductions. This level of detail added thousands of hours to the legal process, and it explains why, as we reach 2026, the complexity of a divorce is often tied directly to the complexity of the couple's tax returns. Simultaneously, the legal standards for children were undergoing a radical transformation. For most of the early 20th century, the tender years doctrine prevailed. This was a legal presumption that young children should almost always stay with the mother. However, as the 1970s and 80s progressed, fathers began to fight for more than just every other weekend visitation. The legal standard shifted to the best interests of the child. This sounds simple, but for an attorney, it opened a Pandora's box of litigation. Instead of a simple presumption, every custody case became a deep dive into the psychological health and parenting abilities of both parties. Attorneys began hiring child custody evaluators, psychologists, and social workers to testify. The attorney's role expanded to managing a team of experts, all trying to define what a child's best interests actually looked like in a fractured home. The economic model of the law firm also adapted to this new complexity. This was the era where the billable hour became the dominant metric. In the 1920s, an attorney might charge a flat fee for a simple divorce decree. But with the advent of massive discovery, expert witnesses, and multi-year litigation over business valuations, a flat fee became impossible. The billable hour incentivized thoroughness. Every phone call, every drafted letter, and every hour spent reviewing a bank statement was tracked in 6-minute increments. This historical trend is why the modern American public often views the divorce process as a financial drain. The system was designed to be thorough and fair, but thoroughness and fairness in a complex economy are expensive. Imagine if a couple in 1990 owned a house, 2 cars, and a 401k. Their attorneys would have to navigate the newly created Qualified Domestic Relations Order, or QDRO. Before 1984, dividing a pension was a legal nightmare that often left one spouse with nothing. The Retirement Equity Act of 1984 created the QDRO, a federal mechanism that allowed a state court to order a pension plan to pay benefits to a former spouse. This was another step-by-step technical process that the divorce attorney had to master. If the QDRO wasn't drafted with surgical precision, the client could lose their entire retirement safety net. This moved the attorney even further away from the courtroom drama and deeper into the realm of ERISA law and tax code compliance. By the time we hit the late 1990s, the divorce attorney was no longer just a lawyer. They were a project manager for a life deconstruction. They were balancing the emotional volatility of custody battles with the cold, hard technical requirements of dividing international stock options and complex real estate portfolios. They were operating in a world where the law had finally caught up to the reality that marriage was as much a financial partnership as it was a romantic one. But as the new millennium approached, a new variable entered the equation that would once again rewrite the playbook for every family law firm in America. The digital age was beginning to dawn, and with it, the nature of evidence was about to change in ways Michael and his 1970s colleagues could never have imagined. We were moving from a world of paper trails to a world of data trails. In our next section, we will explore how the rise of the internet, social media, and eventually mobile devices turned every American's pocket into a potential witness for the opposition. We will look at how the 2000s ushered in the era of electronic discovery, and how the disappearance of privacy changed the potential outcomes for thousands of litigants. But there was another shift happening as well. A growing movement of people who were tired of the billable hour and the adversarial combat. This led to the rise of mediation and collaborative law, a movement that promised a different path. Is it possible to deconstruct a marriage without a war, or does the very nature of the law demand a winner? We will examine the data on alternative dispute resolution and see if it lived up to its potential as we move into the digital frontier. As the calendar flipped into the early 2000s, the American divorce attorney found themselves standing at the precipice of a revolution that was neither legislative nor moral, but technological. This period marked the death of the paper trail and the birth of the digital footprint. In previous decades, a spouse might hide a secret life in a locked drawer or a post office box. By 2005, that secret life was living on a hard drive, and by 2012 it was broadcasted on the cloud. This shift forced the legal profession into a rapid, sometimes painful metamorphosis. The attorney was no longer just a navigator of the courtroom. They had to become a student of digital forensics and metadata. Consider a character named Sarah, a family law attorney practicing in 2008. The legal world she inhabited was suddenly flooded with a new type of evidence, the social media post. In a historical trend noted by the American Academy of Matrimonial Lawyers, by 2010, over 80% of top divorce attorneys reported a massive spike in evidence gathered from social networking sites. Sarah's job shifted from reviewing bank statements to reviewing Facebook walls. Imagine a case study where a husband claims in a sworn affidavit that he has been unemployed and unable to pay child support. Sarah, through the discovery process, uncovers a series of geotagged photos on Instagram showing him on a luxury yacht in the Caribbean, posted by a business partner. This is the era of the digital smoking gun. This technological surge necessitated the 2006 amendments to the Federal Rules of Civil Procedure, which formally introduced the concept of electronically stored information, or ESI. For an attorney like Sarah, this meant that the discovery process now followed a rigorous 5-step technical protocol. Step 1 is the legal hold, where an attorney sends a formal preservation letter to the opposing party, warning them that deleting emails, clearing browser histories, or smashing a smartphone could lead to a charge of spoliation of evidence. Step 2 is collection, often involving a forensic expert who creates a mirror image of a computer or phone to capture not just the files, but the metadata, the hidden data that shows exactly when a document was created, modified, or accessed. Step 3 is processing, where thousands of gigabytes of data are filtered using keyword searches to find relevant information. Step 4 is the review, where attorneys look for attorney-client privilege before Step 5, the final production of evidence to the opposition. This level of detail made the divorce process significantly more complex and consequently more expensive. The potential outcomes of a case could now hinge on a single deleted text message recovered from a cloud backup. Attorneys had to warn their clients that in the digital age, privacy was a relic of the past. Imagine if every private thought you ever typed into a search bar or a direct message could be read aloud in a deposition. That became the reality. By the mid-2010s, the attorney's role included a significant amount of digital damage control, advising clients to go dark on social media the moment a filing was imminent. However, as the cost and conflict of digital warfare escalated, a parallel historical trend emerged: the rise of alternative dispute resolution, or ADR. This was the market's response to the grueling nature of the billable hour and the adversarial courtroom. Mediation and collaborative law began to move from the fringes of the legal profession to the mainstream. In mediation, the attorney's role shifts from a gladiator to a consultant. A neutral third party, often a retired judge or a senior attorney, facilitates a negotiation. The goal is to reach a settlement without a trial. Let's look at the step-by-step reality of a high-stakes mediation in 2015. It begins with the opening statement, where each side outlines their goals. Then comes the joint session, where the parties sit in the same room, unless the emotional volatility is too high. The most critical phase is the caucus. This is where the mediator moves between separate rooms, engaging in shuttle diplomacy. The attorney in this setting must be a master of the compromise. They aren't trying to crush the opposition. They are trying to find a middle ground on the division of a 401k or the specific hours of a holiday visitation schedule. Data from this era shows that approximately 90 to 95% of divorce cases in the United States settle before reaching a final trial. The attorney's value was increasingly measured by their ability to keep their client out of the courtroom. Collaborative law took this a step further. In a collaborative case, both parties and their attorneys sign a contract known as a participation agreement. This document states that if the parties cannot reach a settlement and decide to go to court, both attorneys must withdraw and the clients must hire entirely new legal teams. This created a powerful financial incentive for the attorneys to make the deal work. It was an attempt to humanize a process that had become clinical and cold. It focused on the future of the family unit rather than the destruction of the past marriage. But even with these peaceful alternatives, the complexity of modern assets continued to challenge the profession. We began to see the emergence of the Silicon divorce. In tech hubs like San Jose or Austin, attorneys had to deal with unvested stock options, restricted stock units, and intellectual property valuations. This wasn't just about who got the house, it was about who got a percentage of a patent that might not be profitable for another decade. The attorney had to act as a venture capitalist, projecting the future value of a startup. Now fast forward to 2026. Meet David, a divorce attorney dealing with the current technological landscape. David's cases don't just involve emails and Instagram, they involve the Internet of Things. Imagine if your smart home could testify against you. David recently handled a case study where the logs from a smart refrigerator and a connected thermostat were used to prove that a spouse was not actually residing in the marital home as they claimed, but was instead living elsewhere. The digital trail has moved from the pocket to the very walls of the home. Furthermore, the rise of decentralized finance and cryptocurrency has created a new frontier for the division of assets. In 2026, an attorney must know how to track a transaction on a blockchain to ensure a spouse isn't hiding a significant portion of the marital estate in a digital wallet. The historical trend is clear. The American divorce attorney has moved from proving a moral failure in 1926 to a financial failure in 1976 to a digital failure in 2026. The job requires more specialized knowledge than ever before. You cannot simply be a lawyer. You must be a technician, an analyst, and a strategist of the high-tech world. But as we look at this evolution, we see a new demographic shift that is beginning to redefine the entire industry. While the overall divorce rate in the United States has stabilized or even declined for younger generations, there is one group where the rate is exploding. In the next part of this deep dive masterclass, we are going to explore the phenomenon of the silver divorce. We will look at why couples who have been married for 30, 40, or 50 years are suddenly calling it quits in record numbers. This presents a whole new set of legal and financial challenges that even David in 2026 finds daunting. We will break down the complexities of Social Security benefits, the division of lifelong pensions, and the terrifying reality of long-term care insurance. When the children are gone and the house is paid off, what is left for an attorney to fight over? The answer involves the most complex financial audit in the history of the profession, and we will look at exactly how it is executed step by step. Stay tuned, because the stakes for the fastest-growing segment of the divorce market are higher than they have ever been. In 2026, the American divorce attorney is witnessing a demographic shift so profound it has earned its own moniker in the legal community: the silver divorce. While divorce rates among younger generations have shown historical trends of stabilization or even decline, the rate for adults over the age of 50 has more than doubled since the 1990s. For those over the age of 65, the rate has tripled. This isn't just a statistical curiosity. It represents a fundamental change in the practice of family law. When a couple divorces after 30 or 40 years of marriage, the attorney's role shifts from a focus on the future potential of a career to a forensic audit of a lifetime of accumulated assets. In this environment, the stakes are not measured in potential earnings, but in the finite resources required for a dignified retirement. Imagine a character named Linda. In 2026, Linda is 64 years old and has been married to her husband, James, for 38 years. They live in a suburb of Atlanta in a home they purchased in 1992, which is now fully paid off and valued at nearly $800,000. Their children are in their 30s, established in their own careers, and have children of their own. On the surface, a layperson might think this is a simple case. There are no custody schedules to negotiate, no child support calculators to run, and no arguments over who gets the high-end nursery furniture. However, Linda's attorney, David, knows that this is actually one of the most complex and dangerous types of litigation in the American legal system. In a silver divorce, there is no recovery time. If a 30-year-old loses half of their assets in a divorce, they have 3 decades of peak earning years to rebuild. If Linda loses a significant portion of her retirement security now, she is facing a potential outcome of elderly poverty. The first major battlefield David must navigate is the technical world of Social Security derivative benefits. This is a critical educational point that many litigants overlook. Under federal law, if a marriage lasted 10 years or longer, a divorced person may be entitled to receive benefits based on their ex-spouse's earnings record, provided they are at least 62 years old and remain unmarried. This does not reduce the amount the other spouse receives, but the rules are rigid. David must guide Linda through a step-by-step analysis of her own projected benefits versus 50% of James's benefits. In 2026, with the cost of living rising, this calculation can be the difference between a comfortable life and a struggle to afford basic necessities. If Linda were to remarry before the age of 60, she would lose the right to those derivative benefits based on James's record, a fact that David must emphasize as a high-stakes strategic consideration. Next, we move into the realm of the pension and the Qualified Domestic Relations Order, or QDRO. James spent 30 years working for a major telecommunications firm with a traditional defined benefit pension. To divide this, David cannot simply write a number on a piece of paper. He must apply the coverture fraction, a historical legal formula used to determine the marital portion of a retirement plan. The numerator of the fraction is the number of months or years the couple was married while James was earning the pension, and the denominator is the total length of James's employment. If James worked for 40 years but was married to Linda for 30 of them, only 75% of the pension is considered a marital asset. Linda is then typically entitled to 50% of that 75%. David's job is to ensure the QDRO is drafted with surgical precision to include survivor benefits. Without a specific clause ensuring Linda remains the beneficiary if James dies, her income stream could vanish the moment he passes away, leaving her with nothing. In 2026, this financial engineering is further complicated by the sunsetting of major federal tax provisions. The tax landscape for divorce changed significantly with the 2017 Tax Cuts and Jobs Act, which eliminated the tax deductibility of alimony for the pair and made it tax-free for the recipient for all divorces finalized after December 31, 2018. As we sit in April 2026, Attorneys are now dealing with the expiration of other tax brackets and standard deduction increases. David must run complex simulations to show Linda the potential outcomes of selling the family home, now versus after the divorce is finalized. Historically, a married couple enjoys a $500,000 capital gains exclusion on the sale of a primary residence. If they divorce first and then sell, that exclusion may drop to $250,000 each. If the house has appreciated by $600,000 over 30 years, the tax bill for a post-divorce sale could be staggering. Then there is the silent crisis of silver divorce: health insurance and long-term care. Linda is 64, meaning she is 1 year away from Medicare eligibility. For nearly 4 decades, she has been covered under James's comprehensive employer-sponsored plan. The moment the divorce decree is signed, that coverage terminates. While she may be eligible for COBRA, the premiums for a 64-year-old can exceed $1,500 a month. David must negotiate for James to cover these costs as a form of bridge alimony. Furthermore, they must address the long-term care insurance policy they purchased together 10 years ago. These policies are notoriously difficult to divide or transfer. If the policy is canceled because they can no longer agree on who pays the premium, both Linda and James lose a decade of paid-in equity and face the prospect of paying much higher rates for new, individual policies at their current age. The data from groups like the Pew Research Center suggests that women in silver divorces often see a 45% drop in their standard of living, while men see a drop of about 21%. This disparity is why David must be an aggressive advocate for permanent or long-term spousal support, even in an era where many states are moving toward rehabilitative, short-term alimony. In a 38-year marriage where Linda may have stepped out of the workforce to raise children, the legal argument is that she contributed to the husband's earning capacity at the expense of her own, and she is entitled to maintain a standard of living as close as possible to that enjoyed during the marriage. As we look at the evolution of the attorney's role, we see that by 2026, they have become part gerontologist, part actuary, and part tax strategist. They are navigating a system that was originally designed for young couples with small children, trying to make it fit for seniors with complex medical needs and fixed incomes. The silver divorce is the ultimate test of the equitable distribution model. It requires a deep dive into the history of every bank account, every stock option, and every insurance rider. But as complex as the silver divorce is, there is a new frontier that is making even these seasoned attorneys pause. We are moving into a world where the most valuable assets in a divorce aren't houses or pensions, but digital entities. In our next section, we will explore the rise of the influencer divorce. What happens when a couple's primary asset is a joint YouTube channel with 5 million subscribers and a brand built on the illusion of a perfect marriage? How do you divide the intellectual property of a persona? We are heading into the era of the virtual estate, and the legal battles over digital identity are about to become the most controversial chapter in the history of American family law. In the landscape of 2026, the American divorce attorney has entered a realm that would have seemed like science fiction to the practitioners of the 1920s. We have moved beyond the division of physical land, livestock, and even paper stocks. We are now firmly in the era of the virtual estate. This is where the most valuable asset in a marriage might not be a house in the Hamptons, but a digital persona, a social media handle, or a library of content that generates passive revenue through algorithms. This is the era of the influencer divorce, a complex legal intersection where the attorney must act as an intellectual property scout, a brand strategist, and a digital forensic analyst. Imagine a case study involving a couple named Chloe and Jackson. In 2018, they started a joint YouTube channel focused on home renovation and lifestyle. By April 2026, their channel, Chloe and Jackson at Home, has amassed 4 million subscribers and generates a multi-million-dollar annual revenue through a combination of AdSense, premium brand sponsorships, and a private label furniture line. Their entire public identity, their brand, is built on the narrative of a happy, collaborative partnership. When they decide to divorce, the legal challenge is not just about who gets the physical house they renovated on camera. The challenge is, how do you divide a human brand? Historically, when a family business was divided, the attorney would look at the goodwill of the business, the intangible value of the company's reputation. In 2026, this has evolved into the valuation of the personal brand. Chloe's attorney must argue that Chloe is the face of brand, the primary driver of engagement, and that her right of publicity is a non-transferable personal asset. Meanwhile, Jackson's attorney argues that Jackson was the lead strategist, the primary editor, and the architect of the SEO and algorithm-friendly scripts that made the channel successful. Without Jackson, the channel has no reach. Without Chloe, it has no face. The step-by-step process for valuing such a digital estate is incredibly granular. First, the attorneys must perform a revenue audit of all digital touchpoints. This includes not just the primary YouTube channel, but also secondary platforms like TikTok and Instagram, affiliate link histories, and historical trends of sponsorship rates. Second, they must calculate the lifespan of the content. A video made in 2022 might still be generating $3,000 a month in passive revenue in 2026. This is treated as a residual asset, similar to how an attorney would treat royalties for a musician or a screenwriter. Third, they must account for the pivot cost. If the brand is built on a couple, and the couple splits, the market value of the channel likely drops significantly. The attorney must use a discounted cash flow analysis to estimate what the future earnings of the channel would have been versus what they are projected to be post-divorce. One of the most contentious issues in 2026 is the access to and ownership of the digital handles themselves. A handle like @Chloe and Jackson has a specific market value. In a community property state like California, the handle itself could be considered a marital asset created during the union. But who gets the password? If Jackson gets the handle but Chloe's face is in the profile picture, it creates a massive legal conflict regarding the right of publicity. We are seeing a historical trend where attorneys are drafting complex digital usage agreements. These agreements might dictate that Jackson can keep the handle but must remove Chloe's likeness within 30 days, or that both parties are prohibited from using the joint archive to disparage the other, as any negative press would diminish the value of their shared residual income. This brings us to the rise of the non-disparagement and privacy clauses in the social media age. In the 1950s, a divorce was a private tragedy. In 2026, for people like Chloe and Jackson, a divorce is a public relations crisis. Their attorneys must negotiate a rollout strategy for the divorce announcement. This is a step-by-step management of public perception. If one party goes rogue and posts a series of emotional videos blaming the other, they are effectively burning down the marital barn. The attorney's role is to prove that such actions constitute a dissipation of marital assets. Imagine if a husband in 1980 took $50,000 out of a joint bank account and set it on fire. The court would credit that money back to the wife in the final settlement. In 2026, if a spouse destroys the brand's reputation through social media, the attorney argues that this is the digital equivalent of burning cash. Beyond influencers, the virtual estate includes digital assets like domain names, intellectual property in the form of online courses, and even high-value digital collectibles or NFTs that were purchased with marital funds. An attorney in 2026 must be able to trace these assets through various digital wallets. They must understand the tax implications of transferring these assets, as the IRS has become increasingly sophisticated in auditing digital transactions. The potential outcomes of a case can vary wildly based on whether an attorney knows how to ask for the metadata that proves the existence of a hidden wallet. Furthermore, we are seeing the emergence of the posthumous digital estate in divorce. If a couple has spent years building an automated digital business that runs on AI, who owns the code? Who owns the data collected from their millions of followers? In 2026, data is the new oil, and the database of a joint business is often its most valuable component. An attorney must hire a data appraiser to determine the value of a subscriber list or a customer database. They look at the conversion rates, the average lifetime value of a customer, and the legal permissions associated with that data. This era of family law is defined by the death of the tangible. When an attorney sits down to draft a settlement in 2026, the list of assets often looks like a tech company's balance sheet. There are clauses for the management of the cloud storage, the division of recurring subscription revenue, and the ownership of proprietary algorithms used in a family-run e-commerce business. The complexity is compounded by the fact that many of these digital assets are governed by terms of service from third-party platforms like Google or Meta, which may not recognize a state court's order to transfer ownership of an account. The attorney must navigate these corporate policies, often acting as a liaison between the court and the tech giants. As we see the divorce attorney transform into a digital asset manager, we must also recognize the emotional toll of this new transparency. In the past, you could walk away from a marriage and leave the assets behind. In the digital age, your assets are often your identity. For Chloe and Jackson, losing the channel isn't just about losing money. It's about losing their voice and their history. This psychological weight is making 2026 one of the most volatile years for family law litigation in American history. But as we master the complexities of the virtual world, a much older and more dangerous challenge is resurfacing. While digital assets are difficult to divide, they are at least theoretically traceable. But what happens when a spouse decides to move beyond digital borders and into the world of international jurisdictional evasion? In the next part of this masterclass, we will explore the rise of the global divorce. We will look at how attorneys deal with assets hidden in offshore trusts, real estate in jurisdictions with no extradition or cooperation treaties, and the high-stakes game of international forum shopping. When the world is your playground, the divorce attorney must become a global hunter, and we will break down exactly how they track down a disappearing fortune across 6 continents. The global divorce is the high-stakes chess match of the modern legal world. As we sit in 2026, the American divorce attorney is no longer confined by state lines or even national borders. We are living in an era of unprecedented global mobility where a couple might be married in Paris, live in New York, hold their primary savings in a Singaporean bank, and own a vacation estate in the Cayman Islands. When a marriage like this dissolves, the legal process transforms from a domestic dispute into a multi-jurisdictional war of attrition. This is where the concept of forum shopping becomes the primary weapon in an attorney's arsenal. Imagine a case study involving a couple we will call Robert and Elena. Robert is a high-level executive for a multinational tech firm, and in 2026, his compensation package is a dizzying array of global assets. He has restricted stock units in a Silicon Valley firm, a private equity interest in a German manufacturing plant, and a significant holding in a Swiss-managed hedge fund. Elena has spent the last 15 years managing their 3 children and their various households across 2 continents. When the marriage fails, the first and most critical step for Robert's attorney is a jurisdictional analysis. This is a cold, calculated evaluation of where the divorce should be filed to achieve the most favorable potential outcomes. In the legal world, this is often a race to the courthouse. Historically, the United States has seen a trend where different countries offer vastly different approaches to asset division. For example, England and Wales are often referred to as the divorce capital of the world, because their courts have a reputation for being exceptionally generous to the non-earning spouse, frequently starting from a baseline of a 50-50 split of all global assets, regardless of whose name is on the title. Conversely, Robert's attorney might look at a jurisdiction like Dubai or certain cantons in Switzerland, where the laws regarding the division of premarital or inherited wealth are far more restrictive. If Robert can file first in a jurisdiction that favors the breadwinner, he gains a massive strategic advantage. This creates a high-pressure environment where an attorney must be ready to file papers in multiple time zones simultaneously to ensure their client isn't dragged into a less favorable court system. Once jurisdiction is established, the American attorney must begin the grueling step-by-step process of international discovery. In a standard U.S. divorce, you can serve a subpoena on a bank and receive records in 30 days. In a global divorce, you are dealing with the Hague Evidence Convention. Step 1 is the drafting of letters rogatory. This is a formal request from a U.S. judge to a foreign court, asking that foreign court to compel a witness or a bank to provide evidence. This process is notoriously slow, often taking 6 to 18 months to complete. Robert's attorney may use this delay as a tactical hurdle, while Elena's attorney must hire a local liaison counsel in the foreign country to navigate the specific procedural requirements of that nation's legal system. The most complex hurdle in 2026 is the Offshore Asset Protection Trust. Historical trends show that for decades, wealthy individuals have used jurisdictions like the Cook Islands, Nevis, or Belize to house their wealth. These locations have laws specifically designed to be impenetrable to foreign creditors and, by extension, former spouses. If Robert has moved marital funds into a Cook Islands trust, Elena's attorney faces a terrifying reality. The Cook Islands do not recognize U.S. court orders. To even bring a claim against the trust, Elena would have to fly to the South Pacific, hire a local lawyer, and prove her case beyond a reasonable doubt, a much higher standard than the preponderance of evidence standard used in U.S. civil courts. Furthermore, many of these jurisdictions have a statute of limitations on fraudulent transfers as short as 1 or 2 years. If the money was moved into the trust 3 years ago, it might be legally untouchable under local law. However, the 2026 attorney has new tools to counter these tactics. We are seeing a shift toward the use of Mariva injunctions or freezing orders. This is a powerful legal maneuver where a court can order a global freeze on a party's assets to prevent them from being dissipated or moved before a final judgment. Imagine if Elena's attorney discovers that Robert is attempting to liquidate his Italian real estate. They can rush into a court in Rome and, using the principle of comity and international treaties, obtain an emergency order to stop the sale. This requires a level of international cooperation and legal expertise that was virtually non-existent 40 years ago. The complexity further deepens when children are involved. The 1980 Hague Convention on the Civil Aspects of International Child Abduction remains the primary framework, but in 2026, the speed of international travel has made its application more frequent and more fraught. If one parent takes the children to a non-signatory country, a nation that has not agreed to the treaty, the American attorney essentially becomes a private investigator and a diplomat. They must work with the U.S. State Department and local authorities in an attempt to recover the children. Case studies from the last decade show that these battles can drag on for years, with potential outcomes often being decided by the political climate of the country where the children are being held, rather than the legal merits of the case. As we examine the data, the rise of the expatriate population has led to a surge in what we call the split decree divorce. This is where one country handles the dissolution of the marriage itself, but another country handles the division of property or the custody of children. For example, a couple might be legally divorced in California, but the Italian courts retain jurisdiction over the villa in Tuscany because of the specific land use laws of that region. The attorney must be a master of the conflict of laws, determining which country's rules apply to which specific asset. The financial burden of these cases is immense. The 2026 Global Divorce Attorney is managing a team of forensic accountants, international tax experts, and local counsel in 3 or 4 different countries. Every hour spent on a conference call across time zones is a billable hour, and the cost of translating thousands of pages of foreign financial documents can reach 6 figures before a single motion is even heard. This is the reality of the global elite's legal landscape. It is a system that rewards the party with the most endurance and the deepest pockets. But there is a new evolution occurring even within this high-stakes environment. While the wealthy are fighting over offshore trusts and villas, the average American is facing a different kind of technological revolution. The same tools used to track global assets are now being used to monitor the most intimate aspects of our daily lives. As we move into the next part of this masterclass, we will shift our focus from the global stage back to the palm of your hand. We are going to explore the rise of AI-driven litigation and the emergence of predictive analytics in the courtroom. What happens when an algorithm can predict the outcome of your divorce before you even file? We are entering the era where the attorney's intuition is being challenged by machine learning, and the results are fundamentally changing how cases are settled in 2026. Prepare to see how the software in a lawyer's office is becoming more powerful than the lawyer themselves. By the time we reached the early 2020s, the legal world was already teetering on the edge of a data-driven abyss. But as we navigate the landscape of 2026, the American divorce attorney has undergone a transformation that is nothing short of revolutionary. We have moved from the era of the billable hour as a measure of effort to the era of the algorithm as a measure of outcome. In this part of our masterclass, we explore the rise of predictive analytics and artificial intelligence, tools that have fundamentally re-engineered how a case is built, negotiated, and won. The attorney of 2026 is no longer just a practitioner of the law. They are a pilot of sophisticated machine learning systems that can process a decade of marital history in milliseconds. Imagine a character named Marcus, a seasoned family law attorney in Chicago. In 1996, Marcus would have spent weeks in a law library, pulling dusty reporters and shepherdizing cases to find a precedent that might convince a judge to award a specific amount of spousal support. In 2026, Marcus begins his day by feeding a digital dossier into a secure, closed-circuit legal AI engine. This dossier contains 20 years of tax returns, bank statements, social media metadata, and even the transcripts of the opposing party's previous 3 court appearances in unrelated matters. Within minutes, the AI generates a probability heat map. It tells Marcus that based on the last 5,000 rulings made by Judge Harrison in this specific county, there is a 72% chance of a 5-year alimony award and a 90% chance that the family home will be ordered for sale rather than buy out. This is the power of predictive analytics. Historically, the legal system was governed by the intuition and experience of the attorney, a subjective and often flawed human element. Today, historical trends are no longer vague memories of past cases. They are hard data points. These systems analyze thousands of judicial decisions, looking for patterns that no human brain could possibly synthesize. They look at the time of day a ruling was made, the specific phrasing of the arguments presented, and even the educational background of the judge. For Marcus, this means he doesn't just guess what the potential outcomes might be. He manages them with mathematical precision. The step-by-step process of an AI-driven divorce audit in 2026 is a masterclass in forensic efficiency. Step 1 is data ingestion. The attorney uses an automated discovery portal, where the client uploads every digital shred of their life. Step 2 is pattern recognition. The AI scans for the lifestyle gap. For instance, if a husband claims an income of $100,000, but the AI cross-references his Amazon purchase history, utility bills, and luxury gym memberships to find a spending pattern of $300,000, the machine flags the discrepancy instantly. Step 3 is sentiment analysis. The software reviews 10,000 text messages exchanged between the spouses over the last 3 years. It doesn't just look for keywords, it analyzes the tone, frequency, and timing of communications to create a parenting cooperation score. This score is then used to argue for or against joint legal custody, providing the court with a scientific basis for assessing the best interests of the child. This technological surge has created a massive shift in the economics of the law firm. For nearly a century, the billable hour was the lifeblood of the industry. If it took an associate 50 hours to review documents, the firm billed for 50 hours. But in 2026, if an AI can do that same review in 5 minutes with 99% accuracy, the old billing model collapses. We are seeing a historical trend toward value-based pricing. Attorneys now charge for the strategic insight and the leverage they provide, rather than the time they spend reading. This has lowered the barrier to entry for some litigants, while simultaneously creating a new digital divide. Those who can afford the most advanced predictive software have a tactical advantage that an attorney with a traditional library simply cannot match. Consider a case study involving a high-conflict custody battle in 2026. The mother, Sarah, is using an AI tool called Custody Predict. Her attorney feeds in the father's work schedule, his historical travel data via GPS logs from his vehicle, and the school attendance records of the children. The software generates a simulation showing that the father's proposed 50-50 custody schedule would result in the children being with a third-party caregiver 64% of the time due to his professional commitments. Faced with this data-driven reality, the father is forced to settle for a more realistic visitation schedule before the case even reaches a courtroom. The potential outcome was decided by the data, not by a heated argument in front of a judge. However, this era of automation has also brought about the black box problem. Attorneys in 2026 are increasingly grappling with the ethics of algorithmic bias. If an AI is trained on historical data from a period when the legal system was less equitable, there is a risk that the software will perpetuate those same biases in its predictions. Marcus must be able to explain to a judge not just what the AI predicted, but how it reached that conclusion. This has led to the rise of the legal technologist, a specialist within the law firm whose sole job is to audit and defend the algorithms used in litigation. Imagine if, in 1926, an attorney had a crystal ball that could show them exactly how a case would end. That is essentially what predictive analytics offers today. It has moved the focus of the divorce process from the trial to the settlement table. When both sides are using similar software and seeing the same probability maps, the incentive to engage in a multi-year, million-dollar legal battle diminishes. Why spend $200,000 on a trial when the computer tells you with 95% certainty that the result will be the same as the current settlement offer? This is leading to a more streamlined, though perhaps more clinical, dissolution of the American marriage. Yet, as we automate the financial and logistical aspects of divorce, we find that the human element is becoming even more volatile in a different arena. While the computers handle the math, the public handles the narrative. We are living in a time where a divorce is no longer just a legal proceeding. It is a content stream. The data might tell Marcus how the judge will rule, but it cannot control what happens when the details of the case are leaked to a subreddit or broadcast on a TikTok live. This brings us to the next critical evolution of the American divorce attorney. As we master the digital and the algorithmic, we must face the terrifying power of the court of public opinion. In our next section, we will explore the rise of the PR divorce strategist. We will look at how attorneys in 2026 are managing viral scandals, weaponized leaks, and the intentional destruction of a spouse's digital reputation. When the algorithm predicts a win in court, but the public has already decided you've lost your career and your social standing, what is the role of the lawyer? We are moving into the era of reputation management as a core legal service, and the tactics being used are more aggressive than anything seen in the last 100 years. Get ready to see how the battle for the truth is being fought in the comments section, and how one viral video can override a century of legal precedent. In the high-velocity legal market of 2026, the American divorce attorney has added a new title to their business card, Chief Reputation Officer. We have entered the era of the PR divorce, where the court of public opinion often moves faster and with more devastating force than the court of law. For the modern attorney, the goal is no longer just a favorable decree. It is the preservation of the client's social and professional capital. In 1926, a divorce was a secret to be kept. In 2026, it is a narrative to be managed, and if necessary, weaponized. Imagine a character named Brandon. It is June 2026, and Brandon is the CEO of a prominent green energy startup in Austin, Texas. He is in the middle of a high-stakes series of funding rounds when his spouse files for divorce. In a previous era, this would be a private matter discussed behind closed doors. But in 2026, Brandon's spouse is represented by an attorney who understands the power of the digital echo chamber. Within hours of the filing, a carefully edited video from the couple's smart home security system appears on a popular whistleblower TikTok account. It doesn't show a crime, but it shows Brandon in a moment of extreme emotional distress, out of context. The clip goes viral, amassing 12 million views before Brandon's morning coffee is cold. This is the first step of the modern PR litigation strategy, the narrative ambush. The objective is to create an immediate, negative public sentiment that puts the opposing party on the defensive. For Brandon's attorney, the response must be instantaneous. They are no longer just drafting a legal answer to the petition. They are coordinating with a crisis management firm to launch a counter-narrative. Step 1 for the attorney is the digital lockdown. They must move to secure a temporary restraining order that specifically includes a non-disparagement clause covering all social media platforms and third-party leak sites. However, the legal system often moves at the speed of a dial-up modem in a fiber-optic world. By the time a judge signs the order, the damage to Brandon's reputation and his company's stock valuation is already measured in the tens of millions of dollars. This historical trend marks a departure from the 1980s and 90s, where the primary concern was keeping the divorce out of the local newspaper. Today, the attorney must deal with the permanent, searchable record of the internet. This has given rise to the SEO divorce strategy. When a high-profile individual like Brandon is involved in a contentious dissolution, the attorney hires specialists to flood the search engine results with positive, unrelated content. The goal is to bury the news of the divorce on the second or third page of Google, where statistics show that fewer than 10% of users ever venture. This is a technical, step-by-step process involving keyword optimization, backlink building, and the creation of digital assets that serve as a firewall for the client's name. But the weaponization of the leak goes deeper. We are seeing a trend in 2026 called the drip feed. Instead of releasing all the negative information at once, one side's legal team may strategically leak small, damaging details over the course of several months. Each leak is timed to coincide with major professional milestones, a product launch, a promotion, or a board meeting. This creates a state of perpetual anxiety for the other party, making them more likely to agree to a less than favorable financial settlement just to make the noise stop. The attorney's role in this environment is to act as a forensic investigator of the leak itself. They use digital watermarking and metadata analysis to trace the source of the information. If they can prove that the leak originated from the opposing counsel's office or the spouse themselves in violation of a court order, they can move for significant sanctions, including the reimbursement of attorney's fees or a credit in the final division of assets. Imagine the complexity when AI enters the fray. In 2026, deepfake technology is so accessible that a spouse can create a realistic, but entirely fabricated, audio recording of a private conversation. For Brandon's attorney, the new standard of care involves authenticating every piece of digital evidence with cryptographic hashing. They must hire experts to testify that a recording has not been manipulated by an algorithm. This adds yet another layer of cost and time to the process. The potential outcomes of a case can now hinge on the ability of an attorney to debunk a viral lie before it becomes an accepted truth in the eyes of the public. We must also look at the rise of the cancel culture leverage. In the modern era, being labeled a bad spouse or an absentee parent can result in the immediate termination of brand deals, speaking engagements, and professional contracts. For a client whose income is tied to their public image, an influencer, an author, or a politician, a divorce is an existential threat. The attorney must calculate the cost of this reputation risk, and factor it into the settlement negotiations. They might argue that a spouse's public attacks have diminished the marital estate's total value, effectively committing what the law calls waste or dissipation of assets. If a wife's social media campaign results in her husband losing a $5 million contract, his attorney will ask the court to deduct that $5 million from her share of the remaining assets. Historically, this is a fascinating reversal. In the 1920s, the law was used to protect the sanctity of the marriage from public scandal. In 2026, the law is being used to protect the individual's brand from the wreckage of the marriage. The attorney has become a gatekeeper of the digital self. They are negotiating clauses that dictate how long wedding photos can remain on an Instagram grid, who gets to keep the verified status on a joint account, and what the specific penalties are for every like on a disparaging comment. This shift has also changed the way attorneys communicate with their own clients. In the past, the advice was simply, don't talk to the press. In 2026, the advice is, your phone is a live microphone and every direct message is a potential exhibit. Attorneys are now providing their clients with social media playbooks, dictating exactly what they can and cannot post during the pendency of the case. They are monitoring their own clients' digital output with the same scrutiny they apply to the opposition. The cost of this PR-centric approach is staggering. A top-tier divorce attorney in 2026 is often the conductor of an orchestra that includes publicists, private investigators, data scientists, and SEO experts. This has widened the gap between the divorces of the wealthy and the divorces of the middle class. While Brandon can afford to fight a digital war to save his company, the average American is often left vulnerable to the same tactics without the resources to defend themselves. This creates a new kind of legal inequality where the truth is often less important than who has the better algorithm and the louder platform. As we approach the final chapter of this century-long review, we have seen the American divorce attorney evolve from a moral guardian to a financial engineer, a digital forensic analyst, a global hunter, an AI strategist, and finally a reputation manager. The transformation is complete, but it leaves us with a haunting question. In a world where every detail of a failed marriage can be quantified, predicted, and broadcast to the world, what happens to the concept of justice? Have we created a system that is so efficient and so transparent that it has lost its humanity? In the final part of our masterclass, we will bring all these threads together. We will look at the ultimate conclusion of this 100-year evolution and ask, what does the future of the American divorce look like beyond 2026? Are we moving toward a world where marriage itself is fundamentally redefined by the very legal systems designed to end it? We will explore the emergence of the smart contract marriage and the potential for a world without attorneys. Is the century of the divorce attorney coming to an end? Or are we just getting started? The final revelation will change how you look at every contract you ever sign. Stay with us for the conclusion. As we stand in the final quarter of 2026, we are witnessing the potential conclusion of the divorce attorney's role, as we have known it for a century. The historical trends we have tracked since 1926, from the manufactured hotel raids to the forensic digital audits, are converging into a new highly technical reality, the era of the smart contract marriage. This is the final revelation of our masterclass. We are moving toward a world where the legal dissolution of a partnership is not a dramatic courtroom battle, but the execution of a pre-written code. To understand the gravity of this shift, we must look at how the very definition of a marital contract is being rewritten in the United States right now. Imagine a character named Ethan and his partner Maya. In early 2026, before they were married, they did not just sign a traditional prenuptial agreement on paper. Instead, their attorneys worked together to draft a smart marital trust. This is a decentralized, blockchain-based agreement that governs their entire financial life. In this step-by-step system, every asset they acquire is automatically categorized by the code. When they buy a home, the deed is recorded as a digital token. When they deposit money into a joint account, the software automatically tags the portion that is marital versus the portion that remains separate property, based on the source of the funds. This is a level of transparency that was impossible in 1926 or even 1996. Now, imagine if Ethan and Maya decide to dissolve their marriage in late 2026. In the old system, an attorney would spend 6 months in the discovery phase, hunting for bank statements and tax returns. In Ethan and Maya's case, the discovery phase takes exactly 4 seconds. Their attorneys simply run a query on the marital ledger. Every transaction, every asset appreciation, and every debt is already audited and verified. The potential outcomes of their asset division are not a matter of a judge's discretion. They are the mathematical result of the logic they agreed upon, when they were at their most collaborative. This shift is turning the American divorce attorney from a litigator into a coder and an architect of preventive law. Historical trends show that the legal profession is moving toward what we call unbundled legal services. In the mid-20th century, you hired a lawyer for the entire ride. In 2026, people are increasingly hiring attorneys for specific, high-value tasks while leaving the data management to AI systems. Data from the American Bar Association suggests a significant increase in limited-scope representation. For Ethan and Maya, their attorneys are not fighting in court. They are serving as consultants for the mediation algorithm. We are seeing the rise of AI-driven arbitration platforms where a neutral machine intelligence reviews the ledger and proposes a settlement based on a century of case law and the specific statutes of their state. The step-by-step process of these platforms involves uploading the digital ledger, selecting the desired distribution model, such as equitable distribution or community property, and allowing the AI to run 1 million simulations to find the most tax-efficient way to separate the lives of the parties. This brings us to the radical evolution of the prenuptial agreement itself. For most of the last century, a prenup was a document of distrust, something used by the very wealthy to protect their assets from a newcomer. In 2026, the prenup has been rebranded as the Relationship Operating Agreement. It is no longer just about who gets the house if things fail. It is a living document that governs how the family handles debt, how they save for college, and how they manage their digital footprint. Modern attorneys are now drafting clauses that include digital sunsetting, where certain private photos or shared accounts are automatically deleted or transferred upon the filing of a divorce. This is a proactive management of the reputation risks we discussed in our previous section. Let's look at a case study of a mid-sized law firm in Denver that transitioned to this model in 2025. They stopped charging by the hour for discovery and began charging a flat fee for the design of these digital marital frameworks. The data showed that while their revenue per case dropped, their volume of clients increased because they were offering a solution that avoided the $100,000 warfare of the past. This represents a fundamental shift in the attorney's value proposition. The value is no longer in the conflict, it is in the avoidance of conflict. This is the ultimate conclusion of the no-fault movement that started in 1969. We are moving from a system that asks who is at fault to a system that asks how we can most efficiently execute the prearranged logic of the family. But we must address the lingering human element. Can an algorithm decide the best interests of a child? In 2026, we are seeing the emergence of parenting algorithms. These systems use historical trends of child development and the specific schedules of the parents to suggest custody rotations that minimize stress for the children. While a judge still has the final say in most jurisdictions, the data-driven recommendation of these systems is becoming the baseline for most settlements. An attorney's job in 2026 is to audit the algorithm's logic and ensure it accounts for the unique psychological nuances of their specific client. They are moving from being advocates of a person to being advocates of a family's long-term health. The 100-year loop is now complete. In 1926, the law was a blunt instrument of morality, used by the state to force people into specific molds of behavior. In 2026, the law has become a precision instrument of data, used by individuals to customize their own autonomy. The American divorce attorney has evolved through 5 distinct stages: the moral detective of the 1920s, the jurisdictional strategist of the 1940s, the financial engineer of the 1970s, the digital forensic analyst of the 2010s, and finally the family architect of the 2020s. The final revelation is this: the legal system you enter in the future will be a reflection of the digital life you lead today. Every contract you sign, every account you open, and every post you make is a brick in the wall of your future legal standing. The century of the divorce attorney has been a slow march toward transparency. We have stripped away the secrecy, the shame, and the guesswork. We have replaced them with a system that is colder, faster, and more predictable, but perhaps more honest about the reality of human partnership. As we conclude this deep dive masterclass, you must realize that the history of divorce law is the history of the American family. We have moved from a society that prioritizes the institution of marriage to a society that prioritizes the individual's right to a fresh start. Whether you view this as a triumph of liberty or a tragedy of stability, the role of the attorney has been to bridge that gap. We have reviewed the case studies, the data, and the historical trends that brought us to this high-tech 2026 reality. But even as the algorithms take over the math and the smart contracts handle the assets, one thing remains unchanged from 1926: the human need for closure. The attorney of the next century will likely be a guide through the emotional and ethical complexities that code cannot solve. They will be the ones to answer the questions that metadata cannot address. What is fair, what is kind, and how do we protect the next generation from the fallout of a broken union? The technology has changed, the fees have changed, and the evidence has changed, but the fundamental struggle for a just outcome remains. This concludes our 10-part review of a century of the American divorce attorney. You now have the educational framework to understand not just the system as it stands today in 2026, but the century of friction that built it. But while we have reached the end of this historical journey, the legal world is already preparing for the next disruption. If the last century was about the dissolution of the marriage, the next century might be about the dissolution of the state's role in marriage altogether. What happens when the law is no longer a public record, but a private encrypted key? The next chapter of this story is being written in code as we speak, and it will challenge everything you think you know about the power of the attorney.